They called it the biggest shake-up in Britain's housing market in a generation, and they weren't exaggerating. The Renters' Rights Act 2025 has rewritten the rulebook for every landlord and tenant in England. Evictions, rent hikes, deposits, even pets, nothing will work the same again. Supporters say it's the dawn of fairness and stability. Critics warn it's the start of chaos that could send landlords fleeing and rents soaring. So what's really changing behind the headlines? Let's break down the 10 powerful rules reshaping where millions live and how they could redefine renting in the UK forever.
Number 1. Abolition of no-fault evictions, Section 21. For decades, Section 21 allowed landlords to remove tenants without giving a specific reason, often with only 2 months' notice. The new Renters' Rights Act 2025 formally abolishes this practice, marking one of the most transformative changes in the UK rental system. From 2026 onward, landlords will need to present a legitimate ground to reclaim their property, such as rent arrears, property sale, or serious breach of agreement. This reform seeks to end sudden evictions that left families uncertain about their housing future, offering tenants stronger stability and confidence to plan their lives. It also signals a cultural shift toward viewing housing as a long-term right rather than a temporary privilege. However, the new rule introduces complex adjustments for property owners. Many landlords who relied on the flexibility of Section 21 now face lengthier eviction procedures and potential court delays. Legal experts predict a surge in case backlogs as claims move through the courts under Section 8 grounds, which require documented evidence of tenant misconduct or financial default. Small-scale landlords may find the process costly and stressful, leading some to exit the sector altogether. Industry analysts warned that reduced supply could push average UK rents up by 5 to 10% over the next year if the trend continues. Local authorities and tenant advisory bodies are preparing new support channels to help both sides navigate these changes smoothly. Tenants should expect greater security but stricter rules on conduct, documentation, and timely payments. Landlords will need to maintain clear records of communication, rent receipts, and inspection reports to justify future claims. This transparency aims to reduce disputes and strengthen accountability across the market. While some landlords view this as bureaucratic, others see it as a chance to professionalize operations and attract long-term tenants. The abolition of no-fault evictions therefore represents a balancing act between tenant protection and property rights, reshaping the power dynamics of England's private rental landscape for the decade ahead.
Number 2. End of fixed-term tenancies, shift to periodic agreements. The Renters' Rights Act 2025 officially ends fixed-term assured short-hold tenancies, ASTs, replacing them with rolling or periodic agreements. This means every tenancy will now continue indefinitely until either the tenant decides to leave or the landlord ends it with a valid reason. Previously, landlords and tenants typically agreed to 6 or 12-month terms, offering both sides a clear endpoint. Under the new law, tenancies renew automatically month to month, ensuring that renters are never suddenly left searching for new housing at the end of a contract. This reform aims to create long-term housing stability, reducing the uncertainty faced by millions of households who struggled with frequent renewals and rent hikes tied to short leases. For landlords, this shift introduces a fundamental change in how properties are managed and how future planning works. Many have expressed concern that losing fixed terms makes it harder to forecast property turnover or plan maintenance schedules. Letting agents and property managers are revising standard agreements to comply with new legal templates, and lenders are reassessing how buy-to-let mortgages will be impacted by indefinite tenancies. Some experts predict that this structure could favour professional landlords who operate at scale, while small private landlords may feel squeezed by less flexibility and longer tenant occupancy periods. On the tenant side, it encourages more commitment to maintaining property standards and keeping consistent communication with landlords. The new tenancy model reinforces fairness by requiring reasonable notice periods on both sides, typically 2 months for tenants and longer for landlords, depending on the grounds. It balances tenant security with landlord rights, though it may temporarily reduce available listings as investors adjust. This change reflects the government's broader strategy to professionalize the rental market, transforming it into a stable, predictable environment for renters and investors alike. Number 3. New grounds for possession and the 12-month protection period. Under the Renters' Rights Act 2025, landlords can no longer reclaim their properties without cause. They must now prove a lawful ground for possession. These grounds include reasons such as intending to sell the property, needing it for personal use, or tenant-related issues like serious rent arrears or antisocial behavior. What makes this reform especially significant is the introduction of a 12-month protection period at the start of every tenancy. During this time, landlords are prohibited from evicting tenants for sale or reoccupation purposes, providing renters a guaranteed year of stability. This approach targets unfair move-in, move-out cycles that left families and students repeatedly displaced within short spans. For property owners, the impact is twofold. It limits flexibility, but also demands stronger management discipline. Landlords must now document every step leading up to an eviction claim, including written warnings, rent statements, and evidence of serious breaches. Legal advisors warn that vague claims or missing documentation will no longer hold up in court. As a result, landlords are urged to adopt digital record systems or property management tools that streamline compliance. Those planning to sell must now think well ahead, as failing to anticipate the 12-month restriction could delay transactions significantly. The new law essentially encourages a shift toward professionalism, favoring landlords who treat their portfolios as regulated businesses rather than casual investments. Tenants, on the other hand, gain a sense of permanence that was largely absent in the private sector. They can invest in their homes emotionally and financially, knowing that early eviction is no longer a looming threat. However, this stability comes with responsibility. Maintaining payment discipline, avoiding property damage, and respecting neighbor relations are now critical to sustaining tenancy rights. The 12-month protection rule therefore acts as both a shield for tenants and a structure for responsible renting, redefining how trust and accountability operate within the UK's evolving rental ecosystem. Number 4. Rent rise controls and the ban on bidding wars. One of the most debated elements of the Renters' Rights Act 2025 is the introduction of rent rise controls and the official ban on bidding wars. Previously, letting agents or landlords could invite tenants to offer above the listed rent, fueling competition and inflating local market prices. Under the new law, the advertised rent becomes binding. No open bidding or hidden premium offers will be permitted. Rent increases can now occur once per year, and landlords must provide a 2-month written notice supported by fair market evidence. This policy aims to stabilise monthly costs for renters who have faced record-high rent spikes across major UK cities, with average London rents surpassing £2,500 in late 2024. By limiting speculative hikes, the government seeks to restore transparency and fairness in rental pricing. However, landlords argue that these restrictions interfere with basic market dynamics. They claim that by capping rent adjustments, the legislation may reduce their ability to offset rising mortgage rates, insurance fees, and maintenance costs. Property associations warn that smaller investors may feel squeezed and withdraw from the rental market, especially in regions where profit margins are already thin. Economists predict that if too many landlords exit simultaneously, the supply of rental housing could fall, ironically driving rents even higher in the long term. The reform therefore attempts to balance affordability for tenants with sustainability for property owners, a difficult line to maintain in a volatile housing environment. For tenants, the new rules bring relief and predictability. They no longer have to worry about sudden price jumps or competitive offers pushing them out of reach. Yet the ban on bidding wars also means less flexibility to negotiate or secure properties in high-demand areas. Landlords will now need to adopt transparent rent review clauses and use official valuation benchmarks when proposing increases. Over time, this reform may transform the rental market into a more regulated, evidence-driven system, curbing exploitation while reinforcing accountability on both sides. Number 5. Limits on upfront payments and rent in advance. The Renters' Rights Act 2025 introduces new limits on upfront payments, addressing one of the most burdensome practices in the private rental sector. Until now, many tenants were asked to pay several months' rent in advance, sometimes up to 6, especially if they lacked a credit history or steady employment. Under the new legislation, landlords and agents can request no more than 1 month's rent in advance, creating a fairer entry point for renters who have struggled to save large lump sums. This reform directly targets financial gatekeeping, ensuring that young professionals, students, and low-income families can access housing without unreasonable financial barriers. It also seeks to discourage discrimination against applicants without traditional income verification or guarantors. For landlords, this rule represents a shift in cash flow management and risk perception. Those accustomed to collecting large upfront sums for security or mortgage buffering will now need to rely more heavily on deposit protection schemes and rental insurance products, letting agents predict that landlords may begin screening tenants more thoroughly, focusing on affordability and reliability rather than upfront liquidity. Some may argue that this reform raises exposure to missed payment, especially in high-risk or transient rental areas. However, supporters believe it will strengthen long-term trust between tenants and property owners as contracts become more balanced and regulated. Financial institutions have also begun developing low-cost rent guarantee schemes to help landlords adjust to this transition smoothly. Tenants will benefit from lower initial move-in costs, but they must maintain consistent payment discipline once inside the property. Failing to do so could still lead to eviction under legitimate grounds. The restriction on advanced rent is not only about financial fairness, it symbolizes a broader move toward equal opportunity in housing access. By preventing large upfront demands, the government aims to create a rental environment based on credibility, not capital, a principle that could redefine affordability standards across the UK housing landscape.
Number 6. Ban on blanket discrimination and right to request pets. The Renters' Rights Act 2025 takes a decisive step toward ending discriminatory rental practices that excluded families, benefit claimants, and pet owners from fair access to housing. Landlords can no longer issue blanket bans, such as no DSS, no children, or no pets, in property listings or contracts. This change directly addresses long-standing bias within the rental market, where tenants relying on universal credit or those with dependents often faced automatic rejection. The new law makes it illegal to deny an applicant solely on these bases, promoting inclusivity and equality in housing opportunities. By embedding anti-discrimination into tenancy law, the government aims to ensure that property access is based on behavior and financial reliability, not personal circumstance. The right to request pets is another landmark reform under this act. Tenants may now formally request to keep a pet, and landlords must respond within 42 days, providing a valid reason if they decline. While landlords can still require tenants to maintain hygiene and cover any potential damages, they cannot impose an outright prohibition. This policy reflects changing social attitudes, recognizing pets as emotional companions rather than inconveniences. For families and individuals dealing with isolation, particularly post-pandemic, this right represents a form of emotional stability and improved well-being. Pet ownership clauses must now be handled through written agreements, with optional pet insurance to protect both parties. For landlords, these changes introduce new responsibilities and a cultural adjustment. They must review existing application criteria, update listings, and eliminate discriminatory language from agreements. Property managers will need to balance tenant freedom with practical safeguards like regular inspections and maintenance standards. Some landlords may perceive increased risk, yet experts believe that inclusive renting broadens tenant pools and reduces vacancy rates. This reform pushes the UK's housing market closer to modern social values, where dignity, equality, and compassion define the foundations of every rental relationship.
Number 7. Stronger property standards and expanded investigatory powers. The Renters' Rights Act 2025 introduces tougher property quality standards and gives local authorities greater power to enforce them. For years, poor housing conditions, from persistent damp to unsafe wiring, went unchecked due to weak oversight. Now, councils and designated housing officers are authorized to conduct proactive inspections, request documents, and issue immediate improvement notices where hazards are found. Landlords who ignore these requirements face severe penalties, including unlimited fines and possible bans from operating in the private sector. This heightened enforcement is designed to eliminate substandard rentals, ensuring every tenant lives in a home that meets modern safety and health benchmarks.
Authorities are also developing digital databases to track non-compliant properties, improving transparency for renters searching for reliable accommodation. For landlords, this rule demands consistent maintenance and record-keeping. They must document repairs, safety certificates, and inspection schedules to avoid penalties. The Act strengthens obligations under the existing Decent Homes Standard, requiring proper heating, ventilation, and structural integrity. Landlords will likely experience higher upfront costs for upgrades, especially in older buildings that have not been renovated for years. Yet industry experts argue that compliance will pay off through improved property value and reduced tenant turnover. Landlords who adapt early will find it easier to attract responsible tenants and maintain long-term stability. Those who fail to meet new benchmarks risk public exposure on compliance registers and potential legal action from tenants empowered by the Act's complaints channels. Tenants now gain clearer rights to report unsafe conditions without fear of retaliation. If issues like mold, leaks, or electrical faults go unresolved, they can escalate the matter directly to local authorities, who are mandated to respond. This empowerment shifts the balance of power toward accountability and health-conscious living. As enforcement tightens, the new standard transforms renting from a temporary arrangement into a regulated housing system built on safety, dignity, and trust, essential principles for the UK's evolving rental landscape.
Number 8. Transparent tenancy life cycle and fair notice periods. The Renters' Rights Act 2025 restructures the entire tenancy life cycle, introducing a clearer, fairer system for both landlords and tenants. Under the new framework, every tenancy begins on a periodic basis with legally defined notice rules that prevent abrupt terminations. Tenants can now end a tenancy by giving a 2-month written notice, while landlords must provide longer notice periods that vary depending on their grounds for possession. This measure ensures that both sides have enough time to adjust. Tenants can secure new housing without panic, and landlords can plan maintenance, sale, or reletting with certainty. The government designed these rules to reduce disputes and evictions caused by poor communication or rushed decisions, promoting a stable rental flow that benefits the wider housing market. For landlords, the emphasis on transparency means all communications must now be documented in writing, including rent increases, inspections, or tenancy terminations. Digital correspondence through email or online portals is encouraged to maintain traceable records. Failure to follow these steps could make an eviction legally void. This shift elevates the level of professionalism in property management, ensuring landlords treat tenancies as formal contract rather than casual arrangements. Letting agents and housing solicitors are updating template agreements to match the Act's wording, with particular attention to clauses around notice timing and evidence of delivery. Over time, these requirements are expected to minimize disputes that previously clogged housing courts. For tenants, the new life cycle model provides predictability and empowerment. They can plan moves, negotiate renewals, and even challenge unjust rent hikes with more confidence. The balance of communication creates mutual accountability. Landlords gain clarity over legal expectations, while tenants gain time and assurance. By standardizing notice structures and promoting transparent exchanges, the Act lays the groundwork for a trust-based rental culture, where professionalism replaces uncertainty and every tenancy evolves under clearly defined rights and responsibilities.
Number 9. Transition timeline and application to existing tenancies. While the Renters' Rights Act 2025 has officially received royal assent, its implementation will unfold through a phased transition period stretching into 2026. This gradual rollout allows landlords, tenants, and letting agents time to adapt to the new legal framework. Existing assured short-hold tenancies will not convert overnight. Instead, they will transition into periodic agreements once renewed or when new tenancy terms are signed. The government has indicated that detailed secondary legislation will clarify the exact enforcement dates for each reform, including eviction procedures, rent rise protocols, and property compliance standards. Local councils are being trained to manage this transition smoothly, ensuring consistency across different regions of England. This measured approach prevents sudden market shocks and helps both landlords and tenants understand their rights step by step.
For landlords, the transitional phase represents both an opportunity and a challenge. Those with current tenants under fixed-term contracts can continue operating under older rules temporarily, but they are strongly advised to review agreements now to prepare for the new system. Mortgage lenders and property managers are also adjusting terms, anticipating longer tenancies and slower turnover. Legal experts suggest landlords use this interim period to upgrade documentation, property safety checks, and communication procedures before enforcement tightens. Some analysts predict a temporary increase in sales as smaller landlords exit the market before the full effect of the act sets in. Yet long-term investors are expected to stay, adapting to a more professionalized environment that rewards compliance and reliability. Tenants should pay attention to updates from official channels and housing advice organizations to understand when their tenancy will legally shift to the new rules. Those already renting will gradually gain access to enhanced protections without needing to sign new agreements. This transition period is designed to prevent confusion and ensure that every party is legally prepared for a system built on transparency, security, and equal accountability, marking a pivotal restructuring of the UK rental landscape.
Number 10. Market impact, landlords leaving and rents rising. The final and most controversial outcome of the Renters' Rights Act 2025 lies in its economic ripple effects. As tighter regulations, rent controls, and stricter eviction rules reshape the private rental market, a growing number of landlords are reportedly considering an exit. Surveys conducted by property associations in late 2025 show that nearly 1 in 5 landlords plan to sell at least one property within the next year, citing reduced flexibility, higher compliance costs, and administrative complexity. For many small-scale investors, these changes tip the balance between profit and risk. Analysts warn that this contraction in supply may drive rents upward, particularly in London, Manchester, and Bristol, where demand already exceeds availability. The irony is that reforms designed to protect tenants could temporarily make renting even more expensive as inventory shrinks. For landlords who remain, the landscape will demand greater professionalism and efficiency. Those willing to adapt can benefit from a more stable tenant base, lower turnover, and stronger long-term relationships. The shift away from casual letting towards structured, compliant property management may create a clearer divide between institutional investors and independent owners. Large build-to-rent developers are likely to thrive, filling the gap left by private landlords who exit. Over time, this could lead to market consolidation, fewer landlords controlling more units under regulated frameworks. While this may sound daunting, experts argue it could also bring better standards, predictable rent growth, and a healthier overall reputation for the UK rental sector. For tenants, short-term challenges may include limited choice and higher initial rents, but the trade-off is stability and security under stronger legal protection. Over time, as supply adjusts and confidence grows, the hope is that a more balanced ecosystem will emerge, one defined not by exploitation or uncertainty, but by trust, fairness, and professionalism. The Renters' Rights Act 2025, therefore, stands as both a disruptive reform and a potential foundation for a safer, more equitable future in the British housing market. The Renters' Rights Act 2025 marks a turning point in the UK's housing future, one that promises stability for tenants and a new era of accountability for landlords. By removing no-fault evictions, limiting rent increases, and enforcing stronger property standards, the government has shifted power toward fairness and transparency. Yet, every reform comes with a cost. Rising compliance expenses, tighter legal oversight, and slower eviction procedures may push many landlords to reconsider their place in the market. For tenants, the reward is greater security, but also the risk of fewer homes and higher rent in the short term. This transformation is more than policy, it's a cultural reset in how Britain views renting, not as a temporary fix, but as a sustainable way of life. Both landlords and tenants now stand at a crossroads, forced to adapt to a market that values professionalism, integrity, and respect on both sides. The next few years will determine whether this act builds a fairer housing ecosystem or deepens the affordability crisis it set out to solve. If you rent or own property in the UK, this affects you. Stay informed, review your agreements, and share your thoughts below. Is this reform justice or overreach? Don't forget to like, subscribe, and watch our next video for the latest on the UK housing revolution.